from supplement list for final disclosure item 1, first appeal 149 of 2023.
There is a judgment of Honorable Supreme Court exactly on this point, that who has to be included as a party in suit for specific performance. This is the judgment. Para 5 is the judgments. Data SCC 773. It says, that the suit for specific performance is between the plaintiff and para 5.
Here also there was a
Yes, subsequent purchaser was there, and the court has held that it is upon the plaintiff who wants the execution of the sale for agreement, that to whom he wants to implead as a party. Being he is the person who has executed, who has brought the process into the motion. So he is the one who has to decide who has to be included as a party. However, my lord, I have seen Order 1 Rule 10, wherein if the court wishes, the party may be included. So here the application was filed by the defendant, who were the subsequent purchaser, to be included as a party. So the court held on their application they cannot be included as a party. It is for the plaintiff who has to decide that who has to be included as a party, and his rights can be decided in any subsequent suit. Because if the further parties will be included, the suit for specific performance will convert into a suit for right, title, and interest.
let us see the facts of this case.
Well, first I am reading para 5.
First you read para 1.
Yes. Feeling aggrieved and dissatisfied with the impugned judgment and order dated 3/7/2013 passed in Satyadev Pandey and Kiran Rani Robinson, and order dated 5/8/2013 passed in Gurmeet Singh and Bhatia versus Satyadev Pandey by the High Court of Chhattisgarh at Bilaspur, by which the High Court has allowed the settlement petition preferred by the original plaintiffs and has quashed and set aside the order passed by the learned trial court, allowing the application preferred by the appellant herein for impleading him as a necessary party to the suit filed by respondent number 2 and 3 herein. The original plaintiffs, the original applicant, and the appellant are has preferred the present appeal.
Just a moment. This person Gurmeet Singh Bhatia, who is he?
He was the defendant.
He was the defendant.
He filed an application for impleading him as a party in the case of specific performance.
Being the subsequent purchaser.
Being the subsequent purchaser.
Application for impleading, right? Okay. You read para 2.
The fact of the case leading to these appeals in a nutshell are as follows. Respondent number 2 and 3 herein, the original plaintiffs filed a suit against the respondent number 1 herein, original defendant number 1, for specific performance of the agreement to sell contract dated 3/5/2005 executed by respondent number 1, original defendant number 1 in the court of learned 4th additional district judge Bilaspur. That during the pendency of the aforesaid suit, and despite the injunction against the respondent number 1 herein, original defendant number 1, original owner, not to alienate or transfer the suit property, respondent number 1 herein, original defendant number 1, executed a sale deed in favor of the appellant herein by sale deed number such and such. The appellant herein, purchaser, who purchased the suit property during the pendency of the suit, filed an application in the pending suit under Order 1, Rule 10 CPC for impediment as a defendant in the suit. It was the case on behalf of the appellant hearing that he has purchased the suit property and is a necessary party and proper party to the suit, as he has a direct interest in the suit property. That by an order dated 5/11/2012, the learned trial court allowed the said application and directed the original plaintiffs to join the appellant as a defendant in the suit. Feeling aggrieved and dissatisfied with the order passed by the learned trial court dated 5/11/2012, allowing the application and permitting the appellant herein to be joined as a party defendant in the suit filed by the original plaintiffs. Respondent number 2 and 3 herein, respondent number 2 and 3 herein filed writ petition number such and such before the High Court of Chhattisgarh. By the impugned judgment and order dated 3/7/2013, the High Court has allowed the said writ application and has quashed and set aside the order passed by the learned trial court allowing the impleadment application preferred by the appellants herein by holding that as regard the relief claimed against the original defendants and as no relief has been claimed against the appellant herein, the appellant cannot be said to be a necessary or formal party, that thereafter the appellant preferred a review application which came to be dismissed, hence the present appeal by way of special leave petition. Shri Prashantu Chandra Singh, learned senior advocate, has appeared on behalf of the appellant and Shri M. Shoaib Alam, learned advocate, has appeared on behalf of the original plaintiff. The learned senior advocate appeared on behalf of the appellant has vehemently submitted that once the learned trial court allowed the impleadment application submitted by the appellant herein under Order 1, Rule 10 CPC holding that the appellant is a necessary and proper party, the High Court in exercise of power under 227 of the Constitution of India ought not have interfered with the same. It is vehemently submitted by the senior advocate appearing on behalf of the appellant that as such the appellant has purchased the suit property from the same vendor, and in fact the appellant was the prior agreement to sale holder, and to protect the interest of the appellant is a necessary and proper party. It is submitted that therefore the learned trial court rightly allowed the impleadment application submitted by the appellant. Making the above submission and relying upon the decision of this court in Robinson, Ramaji Bhai Patel, such and such, and the decision of the Bombay High Court in Shri Satvik Developer, such and such, it is prayed to be to allow the present appeals and quash and set aside the impugned judgments and orders passed by High Court and restore the order passed by the learned trial court. The present appeal are vehemently opposed by Shri M. Shoaib Alam, learned advocate appearing on behalf of the original plaintiffs. It is vehemently submitted that in fact the appellant purchased the suit property during the pendency of the suit and that too in violation of the injunction granted by the learned trial court. It is submitted that such a prior agreement to sale upon which reliance has been placed by the appellant is a concocted and forged one. It is submitted that in any case the appellant cannot be impleaded as a defendant in a suit filed by the original plaintiff for specific performance of the agreement to sale or contract to which the appellant is not a party. It is submitted that the original plaintiffs are the dominus litis, and without their consent, nobody can be permitted to be impleaded as defendant. It is vehemently submitted that as such the issue involved in the present case is squarely covered against the appellant in the view of the decision of this court in Kasturi versus such and such. 4.2 in so far of the reliance placed upon the decision of the court in Robin Ramaji Bhai Patel, as well as the decision of Bombay High Court in Shri Swastik Developers by the learned senior advocate appearing on behalf of the appellant. It is vehemently submitted by Shri M. Shoaib Alam, learned advocate appearing on behalf of the original plaintiff, that the said decision shall not be applicable to the fact of the case on hand. It is submitted that in the aforesaid two cases, it was an application by the original plaintiff to implead the subsequent purchaser who purchased the property during the pendency of the suit. It is submitted that as held in this court in Kasturi, it is for the plaintiffs to implead a particular persons as a defendant, and if they do not join, then it will be at the risk of the plaintiffs. It is further submitted that the plaintiff cannot be forced to implead any other person, more particularly who is not a party to the contract, against the wish of the plaintiff. It is submitted that therefore the aforesaid two decisions upon which the reliance has been placed by the learned senior advocate appearing on behalf of the appellant shall not be applicable to the fact of the case on hand. It is submitted that as such the decision of the court in Kasturi clinches the issue and shall be squarely applicable to the fact of the case on hand. Making the above submissions and relying upon the decisions of this court in Kasturi, it is prayed to dismiss the present appeals. 5. We have heard the learned counsel for the respective parties at length. 5.1. At the outset, it is required to be noted that the original plaintiffs filed the suit against the original owner, vendor and original defendant number 1 for specific performance of an agreement to sell with respect to the suit property dated 3/5/2005. It is an admitted position that so far as agreement to sell dated such and such 3/5/2005, of which the specific occurrence was sought, the appellant is not a party to that said agreement to sell. It appears that during the pendency of the aforesaid suit, and though there was an injunction against the original owner vendor restraining him from the transferring and alienating the suit property, the vendor executed a sale deed in favor of the appellant by sale deed dated 10/7/2000. After a period of approximately 4 years, the appellant filed an application before the learned trial court under Order 1, Rule 10 CPC for his impeachment as a defendant. The appellant claimed the right on the basis of the said sale deed as well as the agreement to sell dated 31/3/2003 alleged to have been executed by the original vendor. The said application was alleged to have been executed by the said application was opposed by the original plaintiffs. The learned trial court, despite the opposition by the original plaintiff, allowed the said application, which has been set aside by the High Court by the impugned judgment and order. Thus, it was not an application under Order 1, Rule 10 CPC by the third party. Thus, it was an application under Order 1, Rule 10 CPC by the third party to the agreement to sell between the original plaintiffs and original defendant vendor, and the said application for impeachment was opposed by the original plaintiff. Therefore, the short question which is posed for consideration before this court is whether the plaintiff can be compelled to impede a person in a suit for specific performance against his wish, and more particularly with respect to a person against whom no relief has been claimed by him. An identical question came to be considered before the court in Kasturi, and applying the principle and the plaintiffs is the dominus litis. In the similar fact and circumstances of the case, this court observed and held that the question of jurisdiction of the court to invoke Order 1, Rule 10 CPC to add a party who is not made a party in the suit by the plaintiff shall not arise unless a party proposed to be added has direct and legal interest in the controversy involved in the suit. It is further observed and held by the court that two tests are to be satisfied for determining the question as to who is the necessary party. The tests are: there must be a right of some relief against such party in respect of the controversies involved in the proceeding. No effective decree can be passed in the absence of such party. It is further observed and held that in a suit for specific performance, the first test that can be formulated is to determine whether a party is a necessary party. There must be a right of the same relief against the party claiming to be the necessary party relating to the same subject matter involved in the proceeding for specific performance of the contract itself. It is further observed and held by this court that in a suit for specific performance of the contract, the proper party is a party whose presence is necessary to adjudicate the controversy involved in the suit. It is further observed and held that the parties claiming an independent title and possession adverse to the title of the vendor and not on the basis of the contract are not proper parties. And
Are you in para number 5.2?
5.3.
What are the two tests?
To test that the
Can
controversy.
you read it?
5.3.
5.2.
As discussed herein earlier, whether
No,
respondent.
an identical question. Page 778.
Oh, I was reading that. An identical question came to be considered before this court in custody and applying the principle that the plaintiff is the dominion litis in the similar facts and circumstances of the case. This court observed and held that the question of jurisdiction of the court to invoke Order 1, Rule 10 to add a party who is not made a party in the suit by the plaintiff shall not arise unless a party proposed to be added has direct and legal interest in the controversy involved in the suit. It is further observed and held by the court that two tests are to be satisfied for determining the question as to who is the necessary party. The tests are: there must be a right to some relief against such party in respect of the controversies involved in the proceedings. No effective decree can be passed in the absence of such party. It is further observed and held that in a suit for specific performance, the first test that can be formulated is to determine whether a party is a necessary party. There must be a right to the same relief against the party claiming to be the necessary party, relating to the same subject matter involved in the proceeding for specific performance of the contract to sell. It is further observed and held by this court that it is in a suit for specific performance of the contract, a proper party is a party whose presence is necessary to adjudicate the controversy involved in the suit. It is further observed and held that the parties claiming an independent title and possession adverse to the title to the vendor and not on the basis of the contract are not proper parties, and if such party is impleaded in the suit, the scope of suit for specific performance shall be enlarged to a suit for title and possession, which is impermissible. It is further observed and held that third party or a stranger cannot be added in a suit for specific performance merely in order to find out who is in possession of the contracted property or to avoid multiplicity of the suit. It is further observed and held by the court that the third party or a stranger to a contract cannot be added as to convert a suit of one character into a suit of different character. 5.3. As discussed.
This is the observation from Kasturi.
Yes. There are 5.6. These are the facts. 5.6 and test.
In the judgment which I had referred yesterday, three judgments were referred. One is 1956.
53.
लाए हैं आप? लाए हैं तीनों judgment. 2018, 1953 to 56, and the recent 2024 judgment. आप बाकी सब जजमेंट क्या वो भी हम ही आपके लिए लेके आएंगे? मतलब आई एम एब्सोल्युटली क्लूलेस. जजमेंट निकालने में भी आप लोगों को परेशानी है. व्हाट प्रॉब्लम? मतलब क्या प्रॉब्लम? यहीं पे दे देते, कम से कम जजमेंट देखना जरूरी है ना. Because in the 2018 judgment, the Honorable Supreme Court held that you have to get the sale deed set aside, right? And unless there is a prayer to set aside the sale deed, no relief can be granted, right? That was the finding of the 2018 judgment. In 2024, the court says that he has to join as a party to the sale deed to have an effective decree. Right? So I just want to know whether this custody has been taken care of in that judgment or not, because there have been conflicting judgments on this. That is why the matter was sent for.
In Maharaj Singh, custody's judgment has not been taken care of.
And in this judgment, 2018.
2018 is V. Vijaya Bharti.
Yes.
judgment is a 3-bench judgment which has been followed in this.
2024 judgment is a 3-bench judgment or two judges?
Two pages.
2-bench judgment.
Justice
And
Abhay
in-
Sota and Justice Sudhir.
And in this particular case, as far as I remember while I was going through these judgments, the defendant who wants to be impleaded as a party, they approach the court. Here, those persons have never approached the court. The defendant never come before the court to implead them as a party, and the plaintiff has brought this in the motion, and they do not want to implead anybody as a party. It is a controversy between me and him.
So according to you, they are not necessary.
They are
Party
not
need not
necessary.
be implemented. Then how will, suppose you win, how do we pass a decree?
The controversy is with respect to the specific performance. He can be thereafter. It is between, because what happens, transfer of property at 52 legislation. There, the property should not be transferred during when the suit is in during the pendency of a suit. Now, just to frustrate my right, he has sold his property to the power of attorney holder has sold the property to his sister only, just to extinguish my right or to frustrate my right.
Prior to the execution of the questioned agreement, prior to execution of agreement dated 1/6/2007, the power of attorney holder sold the said suit property to someone else, which was
That is-
subsequently sold to someone else. And
That was prior to the agreement also.
That has never come in my brain. They say that it has been sold prior to the coming of that agreement into the agreement between the parties, but they did not produce any right title interest or any sale deed or any document pertaining to that. Only because I deposed, this question has arisen because I deposed that there was a subsequent sale deed in favor of the sister of the power of attorney holder, the defendant here. Now he never cross-examined me. He never filed any application for impleadment his sister as a party or the other party who he says that the agreement, the property was sold to. It was up to him. He could have filed an application. I do not want to contest against them. There is a specific performance between me and him. Why would I implead the entire world into it and complicate the issue? He never impleaded anybody as party.
But had they been parties, then there is no need to set aside the same deed. They can be asked to
Yes,
join.
had they been a party, they would have come before this honorable court to implead them as a party. Then their adjudication would have been required on that point of reply if their application would have been filed by them. Or even if when this fact came before the learned court, the learned trial court, the court could have impleaded them as a party.
भाई जजमेंट नहीं दे सकते हैं तो साइटेशन देनी चाहिए और हम क्या कर सकते हैं
Citation is 2018-11 SCC page 76.
लिख के दीजिए ना you get all the three citations
Ma'am.
56
53.
53
1993.
18 you have got 18 judgment
Ladyship, I found this judgment, so I thought he will be bringing all those judgment in his favor. I brought this judgment in my favor, which is specific on the point that was raised by my ladyship.
when these kind of issues are being raised right you are first the officer of the court
Yes, I
and
should-
later you should defend your client right I have
Hence
given you
court-
a judgment to examine and those two important judgments which are cited and considered over there you don't consider it necessary to bring it also
No, I can.
What is this? we are into a very important issue
Yes.
whether anybody can be compelled to become a party in a specific performance of contract and whether the plaintiff was at all required to take any step to that effect when the plaintiff himself is saying that it has been transferred to third party.
Lacuna on my part, ladyship. I was never sure that
You have not even checked whether this judgment has been considered in those judgments or not.
this particular judgment has been considered or not. I'm not certain.
2024 वाला judgment दिखाइए लाए ये जो भी judgments थे इनसे मंगा लिए
judgment has not been referred in 2018 law.
Below 2018 judgment has been held to be per union in 2024 judgment.
Yes. Because in that judgment it was held that one has to challenge the sale deed. That view has been now overturned. But at the same time, under this view, the subsequent purchaser has to join in for the purposes of passing a decree in specific performance of contract. Earlier, when this earlier on, when this 2018, this judgment must have been passed when 2018 judgment was in force. At that point of time, you were supposed to necessarily challenge the sale deed. At that point of time. But with the change of law as we stand today, you don't need to challenge the sale deed, but you have to make them party. Otherwise, how the decree would be passed? This is the whole question that we need to examine. And if you don't want to make them party, now it is for the discretion of the court whether the court will pass a suit for decree for specific performance of contract, and whether if the court finds that it is not an executable decree, then under such circumstances, whatever be the consequences has to be seen. Court will not pass a futile decree. It is one thing to say that nobody knew that a third party interest has been created, and then in the execution case somebody comes. And it is another thing to say when it is in the domain of the court that some sale deed has been executed, which as per the plaintiff only some sale deed has been executed. Then under such circumstances, it is for the court to see whether a decree for specific performance will be passed under such circumstances. Isn't it? 2018 judgment was B. Vijay Bharti. Now, in this particular judgment, in 5.2, there are two things which are mentioned. Right? An effective, no effective decree can be passed in absence of such party. So, how do you satisfy this test? Can any effective decree be passed in absence of the third party?
Leadership one, if may I read 5.6, 6 and 7, then I will come back. The fact of the case is clear, Leadership.
Yes.
Now 5.6. Therefore, considering the decision of this court in Kasturi, the appellant cannot be impleaded as a defendant in the suit filed by the original plaintiffs for specific performance of the contract between the original plaintiff and the original defendant one, and in a suit for specific performance of the contract to which the appellant is not a party, and that too against the wish of the plaintiffs. The plaintiffs cannot be forced to add party against whom he does not want to fight. If he does so, in that case, it will be at the risk of the plaintiff. Now, so far as the reliance placed upon the decision of this court in Robin Ramji Bhai Patel and the decision of Bombay High Court in Sri Swastik Developers relied upon by the learned senior advocate for the appellant is concerned, the aforesaid decision shall not be applicable to the fact of the case on hand. As in both the aforesaid cases, it was the plaintiff who submitted an application to implead the third party's subsequent purchasers who claimed title under the vendor of the plaintiff. Position will be different when the plaintiff submits an application to implead the subsequent purchaser as a party, and when the plaintiff opposes such an application for impleadment. This is the distinguishing feature in the aforesaid two decisions and in the decision of the court in Kasturi. In view of the above, and for the reasons stated above, we are in complete agreement with the
5/6 SCC 733 लिख रहे हैं. 5/6/733. आपने सारे जजमेंट्स दे दिए? जजमेंट्स लिख के दे दिए?
फॉरवर्डेड टू व्हाट्सएप.
किसको? कोर्ट में भी बैठ के व्हाट्सएप चलेगा क्या? We'll see this judgment. Let Kasturi judgment come, we'll come back to it. Now you tell us that 2005 volume 6 SCC page number 733. Can a court pass an order for execution of sale deed on behalf of the vendor who does not have the title anymore?
leadership, the subsequent
Can the court pass a judgment directing the defendant to execute a sale deed who does not have a title over the property for any reason whatsoever, even subsequent sale deed? Is it permissible in law?
But it is
So
the
therefore-
subsequent sale deed is always barred by section 52 of the transfer of property. When the list was pending, the case was pending, just to frustrate my rights, even the malafide.
Therefore, there are two things which is required to be examined in a specific performance of contract when third party right is created. One is whether he is a purchaser bona fide and without notice. This is also something which is required to be adjudicated in a case. Right? We cannot assume that merely a person is a sister, therefore the transfer is not bona fide. We will not assume that. Right? There is no question of any assumption. Right? And the second question is whether what is the kind of right the third party is asserting. Could be that the third party is asserting some right on the basis of a previous agreement of sale, or maybe the third party is asserting a right which is backed by another sale deed. As he says so, they have also not produced that sale deed. So we will not take cognizance of that, which they have not produced. You have also not produced that sale deed, because that sale deed would have indicated that how this property is coming to you. You have also not produced it.
The sale deed is between.
No, your sale. The
My
certified copy is very much available. When you are deposing that there is a sale deed, so you must have seen it. You have not produced it.
He is not admitting to it, leadership. There is no statement by the defendant. There is a statement by me. There are as many statements by me that there was a specific performance. There was
We
a
will
signature.
see
there was
those.
an argument.
Every statement is subject matter of scrutiny,
Yes.
right? Be it from their side or be it from your side.
Yes.
But when it comes from the plaintiff that admittedly there is an execution of a sale deed in connection with the same property by the same vendor to a third party, then under such circumstances you cannot dispute this fact. You will not be in a position to dispute this fact. Now tell us, when the vendor has lost title over the property, can the court pass a decree for specific performance of contract in connection with the same?
Leadership, at the same time, what has been observed that if further parties are impleaded and right title and interest has to be decided that who has the better title and who has the title and possession over the suit property, then it would no more be a suit for specific performance. Then it would be a title suit where the title has to be decided first, that what title the
Then-
person is holding.
Then there will be two sale deeds which for the same property, and the court will decide that which of the sale deed will prevail.
Yes. Then that would, the scope of specific performance act would definitely be widened with that. This is a contract between me and him. Now, whatever be the repercussions, if he has played fraud or whatever, during the pendency he has subsequently sold it, he will have to face the music. This is, independently it has to be decided on its own that whether I qualify for a decree for specific performance or not.
No, you see, the two tests which has been laid down by this judgment in Gurmeet Singh Hatia. One test is, I will come back to the two test. Two tests are to be satisfied for determining the question who is a necessary party. First is there must be a right to some relief against such party in respect of controversies involved in the proceedings. So far as this test is concerned, you have a right of some relief, asking him to join as a co-vendor of the property by virtue of 2024 judgment. That right you have. Further is no effective decree can be passed in absence of such party. Now, so far as the first is concerned, so the point is that when the property has already changed hands, can any effective decree be passed?
That has been decided in this edition. Here also there was a subsequent purchaser. Subsequent purchaser came before this honorable court that his rights are being infringed. Then also his application was denied just because there was a suit of specific performance between the plaintiff and the defendant. Here that person has not even approached this court. Defendant never brought that person before this court. The court never thought that the person is an important person to be impleaded as a party. Even the court has the right, could have been impleaded the defendant as a party if the court feels that he is a necessary party to the suit. In 2024 judgment, what I could understand, ladyship, subject to correction, the plaintiff impleaded him as a party for subsequent cancellation of the sale deed. And then it has come that subsequent cancellation of the sale deed is not required, he has to be impleaded as a party. Here the plaintiff, the defendant, the other party who has the right, the court, nobody impleaded him as a party. Anybody could have filed that Order 1 Rule 10 application before the Honorable.
You see, in this case, in the case of Kasturi, the parties who were sought to be added were respondent number 1 and 4 to 11. And by deciding as to whether they are the necessary parties or not, the court has observed that these respondents have no direct interest in the suit for specific performance because they are not parties to the contract, nor do they claim any interest from the parties to the litigation. But here is a case where a third party right is created, that is created through a party to the litigation. It is one thing to say a person is in possession of property by virtue of adverse possession, right? That party may not have any interest in the specific performance of contract because that adverse possession can be agitated at any point of time, right? Even if there is a specific performance of contract. So in case of Kasturi, you just have a look at this. Look at it. You have Kasturi?
Just look.
You look at it.
Taking Kasturi into consideration, it has further, this particular judgment I am relying, has further widened.
You will see that. Now we have 2024 judgments that how a relief under Specific Performance Act has to be given. In 2018, the law was, as it stood in 2018, when that judgment was passed, that unless you challenge the subsequent sale deed, no specific performance can be granted. That has been taken care of by saying that no, the third party can be asked to join as a co-vendor in the property, right? So that this is the new law which has come up. And so far as Kasturi is concerned, the Kasturi's judgment is very clear on the point that these persons, you have seen that,
Yes.
these persons, they were claiming independent title.
Yes.
They had no interest, nor the vendors had passed on the property to them. Right? So the facts in Kasturi case was totally different. And now after coming into force, and this judgment when it was passed, this one, this 2020 judgment, right? It was passed when? It was passed when 2018 judgment had also come into force.
In 2018 judgment, it was held that the subsequent sale deed has to be challenged.
Challenged.
In 2020,
You cannot challenge the subsequent sale deed without making them a party,
Yes.
isn't it?
Yes.
You cannot challenge it unless they are party in the proceedings. So there was at that point of time there was a law that you have to challenge the sale deed, then only any relief can be granted. That was contrary to the earlier judgment in 1956. 53 वाला judgment था, लेके आए लेके आइए. आप लोग जजमेंट नहीं लेके आते हैं ना, क्या बोलेंगे? जब लेके नहीं आए तो पढ़े तो नहीं ही होंगे 100%. पढ़े हैं? बताइए 53 का फैक्ट. पढ़े हैं तो बताइए. बिना फैक्ट के कोई जजमेंट नहीं होता है. हाँ बताइए क्या फैक्ट है? हाँ? What have you gone through it? ये जो प्लासिटम और फोन से जो जजमेंट देखते हैं ना, ये चलने वाला नहीं है ज़्यादा लाइफ में. AI से AI will they will take you anywhere they want to. आपको AI को कहीं लेके जाना है कि आप AI से ड्रिवन हो जाइए.
AI is not reliable.
Reliability की बात ही नहीं है.
It decreases the competency.
You will not give your brains. भाई AI is a tool to utilize such that you apply your independent brain. अगर AI आपका ब्रेन बन जाएगा तो आप लोग की ज़रूरत क्या है? AI है हमारे पास, हम AI से अपना लगा के जजमेंट करते रहेंगे यहाँ पर. अभी she has read the entire judgment almost, जो घर में नहीं पढ़ी होगी, I am sure.
No, this judgment I read. That's why it specifically pointed out the facts as well.
It's good. It's good that you have read it. कहाँ है? 56 वाला judgment. 53 है ना?
53 volume 2 is
दुर्गा।
Durga.
Pass on page number.
हाँ, निकाल दीजिए प्रिंट। चलिए ठीक है, वी हैव टू डिसाइड। वैसे मद्रास हाई कोर्ट के जजमेंट्स हैं दैट दे आर नेसेसरी, जो आपने नहीं देखे होंगे और नहीं देखे होंगे। अब हम एडजर्न नहीं करेंगे इसलिए,
नहीं,
फिर हम आपने करेंगे।
No, I will not be seeking.
मद्रास हाई कोर्ट के सब्सिक्वेंट जजमेंट्स हैं, नॉट वन, आई थिंक देयर आर टू। वो भी बस उतना एआई में देखें। आई हैव टू रीड द जजमेंट टू फाइंड आउट दैट इज व्हाट इज द रेशियो ऑफ द जजमेंट।
Leadership, what I could understand, again subject to correction and revision, the two judgments that are relying upon by this honorable court is, like whether there was a challenge to a subsequent sale deed yearly, and then deciding that issue whether subsequent sale deed has to be challenged or not, the court came to a finding no, it is not required to be challenged. Only thing is they has to be impeded as a party. In this particular judgment, the very question is whether who has to be impeded as a party. The court came to a finding that without the consent of the plaintiff, nobody else can be impeded as a party because they are not party to the contract between them. So this is the very basis, the very question that has been determined is in 2022 judgment, where nobody has come before this honorable court that their rights are being infringed.
I'm not much concerned with whom have you made party, not made party. I'm concerned with the decree that
Yes, I understand.
may be passed. I will not pass a futile decree under any circumstances. Whenever the court is passing a decree, then under such circumstances the sale deed will take its effect from the date it is executed.
Yes.
Then on that day when the sale deed is executed, the vendor does not have a title.
And the court also has come to the finding that just because there would be multiplicity of the cases in the suit, the party cannot be impeded. Even that is a finding in this particular case.
तो जजमेंट निकला गोराई जी हैं बुलाई जरा। all the three situations, objection at the stage of execution, directing the subsequent transferee to sell the property, and also passing a decree irrespective of the third party, have been considered in this three judges bench of Honorable Supreme Court. And Honorable Supreme Court ultimately held that the only form of decree which can be passed is to ask the subsequent purchaser to join. You can just 37. जी जो हमारी मैट्रिक्स आखिर करते हैं और नेक्स्ट डेटिंग पोस्ट उस पर बहुत ज़्यादा कम करने क्योंकि एडवोकेट्स ना जजमेंट्स पढ़ते हैं ना जजमेंट्स लिए हैं, ठीक है। तो वी कैन बी रेकलेस। हम लोग को अपना सारा जजमेंट जैसे ये वाला कल वाला जजमेंट उसमें जो भी रेफर्ड जजमेंट है हम लोग का सब सॉफ्ट कॉपी हम लोग प्रोवाइड करने की सकते बिना बैकअप जजमेंट्स पढ़े हम इस तरह से कॉपी पेस्ट नहीं कर सकते, ठीक है। तो यू हैव टू फोकस ऑन नेक्स्ट डेज, दे आर नॉट पेड नहीं लेके आते हैं वो पुराने जजमेंट्स पढ़ के नहीं आते, सब तो गलती हो जाएगा ना हम लोगों से, ठीक है। तो यू हैव टू टेक केयर ऑफ दैट। आप हमसे रोज़ शाम को एकदम पूछ लेंगे, लंच टाइम में पूछ लेंगे नेक्स्ट डे कौन सा माइक्रो पोस्ट है। Anyways, we give a judgment on this. We'll see what is to be done. Now you tell us, so far your merits are concerned. Where is the power of attorney?
That has not been brought. It is an admitted fact between both of them.
So how do we know that what right did the power of attorney holder have with respect to the
He has admitted he is the best, but he has not admitted I do not have the power.
his conduct and his direction to him will bind the owner of the property. Unless the power of attorney is placed on record, how do we know that to what extent he was given the right, and further, did he have the right to contest the suit on their behalf? That also can come only through the power of attorney. It is one thing to say that he has got the right to sell the property. It is another thing to say that he has got the right to contest a suit on their behalf. They are not one and the same thing. And you said that power of attorney photocopy was given to you.
For the reference.
For the reference, you did not even bring that on record. That was a registered power of attorney. You did not even get a certified copy of that.
That has not been.
So in absence of the power of attorney, how does a court come to a conclusion that the vendor had the right to defend the vendor had a right, the power of attorney had a right to defend the vendors, firstly, and how do we know that what was the nature of power of attorney which was granted?
Because that is not being disputed by him. It is an admitted fact between both the parties.
If two parties admit
Yes.
that railway station is to be sold, court will become a party to it. You are seeking execution through a process of court. Where is the power of attorney? And that is why you see the court has taken note of this, that you have not even produced the photocopy of the power of attorney. Where is the power of attorney? In the absence of that power of attorney, and you have impleaded him in his individual capacity. You have not impleaded him by saying that these are the persons and he is being represented through power of attorney.
No, he has been
As individual person.
As an
So-
individual person, power of attorney.
No, you see that is not the way in which the cause title is to be drafted. Cause title was to be drafted making them, the vendors as party, represented through the power of attorney. So the way you have drafted the plaint, showing he is the only defendant, without even indicating that he is representing whom, narrations are there in the main thing, and then it is not clear from the records as to whether he is otherwise entitled to defend the vendors. Those things are absolutely absent. On the face of it, it is absent. The question of executing a decree will come only when the court is satisfied that you are entitled to a decree. How do you answer this?
These are the facts. He has been implemented as a party in person, as a power of attorney holder. The description of the suit property, how it has traversed to him, and how
he has not been treated as a power of attorney. See the plaintiff. He has not been implemented in the capacity of a power of attorney.
in person and in the plate.
Body will not decide. The cause title should indicate that these are the persons and he is being implemented as a power of attorney holder of these persons.
That is not.
Normally, you see, it has to be like this. Suppose there is a director of a company or managing director of a company. He is implemented. And in the body it is mentioned that he is the managing director. Will that decree bind the company? No. So, your basic ingredients is absent. The court has taken note of all that. Even the money receipt you could not prove.
I mean, money receipt has been proved by the person who has typed it, and the deposition of PW4 who has stated that in front of him it was signed by the defendant and the plaintiff. PW4 is there.
The evidence of PW4 has been considered. We will see where has he gone wrong. Where has the court gone wrong in appreciating the evidence of PW4? Let us see that and then you refer to the paragraph.
The position of PW4 is at internal page 11 of the Indian judgment. And may I directly read the deposition now?
You can read it from wherever you want.
I'm looking for the deposition.
You should read it from the deposition.
No.
But I just wanted to know from her as to what error has the court committed in appreciating the evidence of PW. You just see page number 43, internal page 26.
You can observe in page 27.
You come to page number 26 first. Further, the money received was proved by witness PW4. Kindly read this.
Was proved by witness PW4.
उनको पढ़ने दीजिए.
Further, the plaintiff has pleaded the writ.
Further, the money received was proved by PW4. What?
The plaintiff, I am reading from there, just 2-3 lines.
Okay.
over.
Yes.
The plaintiff has not examined any witness to the money receipt and submitted that witness Vinod Kumar Singh has died and witness Arvind Kumar Singh was not examined before the court. Now, this particular finding that has no witness has been examined to the money receipt. The plaintiff has not examined any witness to the money receipt and submitted that Vinod Kumar Singh and Arvind Kumar Singh has not been examined in the court. Further, the money receipt was proved by witness PW4, who was an advocate clerk who stated the defendant had signed on it. However, when questioned as to whether he has seen any monetary transaction happening between the plaintiff and the defendant, the witness submitted that he has not seen. Further, in absence of examination of the witnesses to the money receipt, it is the word of the witness who claims to be the present at the time of making of the money receipt and the maker of the instrument, the purported executor of the document, and the defendant has denied his signature on the money receipt, and the a witness who was brought to prove the document does not have his presence recorded on the document. Hence, he is neither the maker
So
of the
therefore,
document.
the court is drawing an inference that this witness who has said that they have signed in his presence is not recorded as such in the money receipt. Money receipt has two witnesses. One had died and the other did not witness. Right? So it is just a word against word. Anybody can come and depose that in my presence it has been executed. And he is the advocate clerk deposing.
Yes, he is
He is not somebody who is known to the parties. He is an advocate clerk deposing. And you just read it further.
The purported executor of the document, the defendant has denied his signature on the money receipt, and the witness who was brought to prove the document does not have his presence recorded on the document. Hence, he is neither the maker of the document nor the witness to the money receipt. Further, the plaintiff has also not brought on record any documentary record of the transaction showing how the large amount of cash was paid by him. That is, bank statement showing withdrawal of the amount from his account, or if the payment was made by the demand draft or check, the record of those documents. Hence, in absence of the legal notice being brought on record and the payment of consideration being proved, it cannot be said that the plaintiff was ready and willing and already performed the substantial part of his obligation under the agreement for sale dated 1/6/2007. Therefore, not only has the agreement dated 1/6/2007 not been proved, even the fact of the plaintiff having performed or ready and willing to perform his obligation under the agreement also could not be proved by the plaintiff. Therefore, in the light of the aforesaid discussion, the relief of the specific performance of the agreement dated 1/6/2007 cannot be granted. Further, the plaintiff had also prayed for the relief of recovery of possession of the suit property. However, the fact that the agreement for sale of the suit property cannot be specifically enforced in favor of the plaintiff does not entitle the plaintiff to recover the possession. Coming to issue number
No,
one.
no, pause. With respect to money receipt, which evidence do you want to raise? Is there any error in recording the evidences by the learned court, or is it something the court has missed? Because you see, we are in first agreement. While appreciating the oral evidences also, we will see that whether the court has erred in appreciation of the oral evidence. If there is any particular evidence, if you want to place from the oral evidence with respect to money receipt, kindly place it during now.
PW4 is
Yes,
the
read it. You just tell us which paragraph you are referring to of PW4.
I know the plaintiff of the suit, the money receipt dated such and such executed by the
Just a
defendant.
moment. What is his name?
Govinda.
He is PW.
PW4.
PW4. Govinda. Yes. Yes, please.
I know the plaintiff of the suit, the money receipt dated 1/6/2007 executed by the defendant in favor of the plaintiff was signed by Sudev Chandra Mandal in my presence, and after typing the defendant had put his signature in my presence, I know and identify money receipt dated 1/6/2007. This may kindly be marked as exhibit. The statements made above are true to the best of knowledge, belief and information. Now the cross-examination part. मनी रिसीट डेटेड 1/6/2007 सुरेश प्रसाद और सूरज कुमार अदानी के बीच में हुआ था। इस मनी रिसीट को एससी मंडल ने टाइप इस पर मेरे समक्ष एससी मंडल सूरज कुमार बदानी और 2 विटनेस ने भी साइन किया था। इस मनी रिसीट को एग्जिबिट 3 किया जाता है विद ऑब्जेक्शन, क्रॉस ऑब्जेक्शन ऑन बिहाफ ऑफ द डिफेंडेंट। मैं 2000 से दीपक दास का एडवोकेट क्लर्क हूँ। सूरज प्रसाद जी ने मनी रिसीट को टाइप करने के को दिया। ड्राफ्ट मनी रिसीट को किसने किया याद नहीं। यह मनी रिसीट को सिग्नेचर होने के बाद, केस फाइल होने के बाद देखा। इस मनी रिसीट में सूरज कुमार भदानी, अरविंद कुमार सिंह और विनोद कुमार सिंह किए थे।
ये क्या मतलब हुआ? ड्राफ्ट मनी रिसीट को किसने किया याद नहीं?
ड्राफ्ट
किसने
who has
किया?
drafted the money receipt?
ये मनी रिसीट को signature.
इस मनी रिसीट में सूरज कुमार भदानी अरविंद
This
कुमार
para
सिंह
7 पढ़िए. यह money
यह
receipt.
मनी रिसीट को सिग्नेचर होने के बाद केस फाइल होने के बाद देखा, मतलब उस समय देखा था सिग्नेचर होने के बाद, अभी केस फाइल होने के बाद देखा। इस मनी रिसीट में सूरज कुमार भदानी, अरविंद कुमार सिंह और विनोद कुमार सिंह साइन किए थे। सूरज भदानी का एक ही सिग्नेचर था। दीपक दास एडवोकेट द्वारा बनाए गए सारे दस्तावेज का जानकारी नहीं होता है, लेकिन करीब करीब जानकारी रहता है। पैसे का लेन देन होते हुए मैंने नहीं देखा। ऐसी बात नहीं है कि ये मनी रिसीट मेरे सामने अंकित हुआ ना ही निष्पादित हुआ। ऐसी बात नहीं है कि मैं वकील साहब के कहने पर झूठी गवाही दी।
Deepak Das has been examined.
दीपक दास वो उसका एडवोकेट क्लर्क।
And this
Leadership small.
Suresh Prasad has been examined.
He is the plaintiff.
सुरेश
No,
प्रसाद is
not
the
Suresh Prasad. एक और.
SC
Mandal.
Mandal has PW.
PW.
Sudev Chandra Mandal. He was the title.
Yes, please read it.
I know the plaintiff of this suit. The agreement for sale dated 1/6/2007 executed between plaintiff and the defendant was typed by me. That after typing, the plaintiff and defendant have put their respective signatures in all the pages in the agreement in my presence. Thereafter, all the witnesses have put their signatures as witnesses. I have put my signature as typist. Thereafter, Shri S.S. Singh, advocate, have identified all the signatures in the agreement, and thereafter has been notarized by the notary public, Shri Virendra Nath Pandey. I know and identify the agreement. This is the original agreement for sale dated 1/6/2007. This may kindly be marked as exhibit. The statement made above are true to the best of knowledge. Leadership take
Just a moment. He is not talking about money receipt. He is not talking about typing of money receipt. He is only talking about typing of the agreement.
Yes.
So he has not stated that he has typed the money receipt. And this PW4 says that he has typed the money. This
Yes, because his signature is also there in money receipt. Even if he missed out saying the signature is there, and PW4 has identified that it was typed by him. The agreement
is
cross-examination.
cross-examination.
अग्रीमेंट डेटेड 1/6/2007 मैंने टाइप किया था। टाइप होने के वादी सुरेश प्रसाद और प्रतिवादी का नाम याद नहीं है। दोनों ने मेरे सामने हस्ताक्षर किया था इकरारनामा पे। उस अग्रीमेंट के गवाह भी थे, कौन थे याद नहीं है। अग्रीमेंट नोटरी हुआ था, याद नहीं है, नहीं मालूम। इसे हुआ था या नहीं मालूम। इसे प्रदर्श 1 अंकित किया जाता है। विद ऑब्जेक्शन, the witness has not identified who the defendant was and who the witness to the agreement was. Cross examination on behalf of defendant. यह इकरारनामा कितने पेज में टाइप है याद नहीं है। मैं कई इकरारनामा या दस्तावेज टाइप करता हूँ, उसका मैं कोई रजिस्टर मेंटेन नहीं करता हूँ। 1/6/2007 को मैंने किन दस्तावेज टाइप किया था याद नहीं। सुरेश प्रसाद को मैंने अग्रीमेंट टाइप करने के बाद, सुरेश प्रसाद को मैं पिछले 30 सालों से जानता हूँ। मुझे याद नहीं है मैंने सुरेश प्रसाद का क्या क्या दस्तावेज टाइप किया, याद नहीं। ऐसी बात नहीं है कि मैंने अग्रीमेंट टाइप नहीं किया और मैं झूठी गवाही दे रहा हूँ। This PW3 is the advocate who was present, and in his presence the agreement was executed between the parties, and his signature is also there in the agreement. May I read
In the money receipt.
No, in the agreement.
Agreement is saying that somebody has signed it. They also do not.
In the money receipt, there is no signature of anyone. I know the. May I read please?
Just a moment. You are reading PW?
PW3. I know the plaintiff of the suit, the agreement for sale dated 1/6/2007 executed between the plaintiff and the defendant was typed by Sudev Chandra Mandal. That after typing, the plaintiff and defendant have put their respective signatures in all the pages of the agreement in my presence. Thereafter, all the witnesses have put their signatures as witnesses. I have put my signature as advocate in the agreement and have identified all the signatures in the agreement, and thereafter the same has been notarized from the notary public, Shri Virendranath Pandey. I know and identify the agreement. This is the original agreement for sale dated 1/6/2007 in which I have put my signature in all the pages. This may kindly be marked as exhibit. The statement made here. Now the cross-examination. The agreement for sale dated 1/6/2007 मेरे सामने यह agreement for sale dated 1/6/2007 मेरे सामने बनाया गया जिस पर सूरज मदानी और सुरेश प्रसाद का सिग्नेचर है. दोनों ने मेरे सामने हर पृष्ठ पर हस्ताक्षर किए. गवाहों ने भी मेरे सामने हस्ताक्षर किए जो कि SC मंडल टाइप किया था. गवाहों का नाम याद नहीं है इस अग्रीमेंट के. सभी ने हस्ताक्षर मेरे सामने किया. मैंने भी हर पेज पर हस्ताक्षर किया. नोटरी VN पांडे में किया है. इस अग्रीमेंट पर गवाह और वादी और प्रतिवादी हस्ताक्षर को प्रदर्श 1/1, 1/2, 1/3, 1/4, 1/5 वादी के हस्ताक्षर व प्रदर्श 1/6, 1/7, 1/8, 1/9 और 1/10 प्रतिवादी के हस्ताक्षर को 1/11, 1/12, 1/13, 15 क्रमशः अंकित किया जाता है. क्रॉस एग्जामिनेशन ऑन बिहाफ ऑफ द डिफेंडेंट. यह अग्रीमेंट 3 या 4 पेज में टाइप हुआ था. एग्जैक्टली कितने पेज का था याद नहीं है. 1/6/2007 को यह अग्रीमेंट हुआ था. कौन दिन था याद नहीं है. गवाह के रूप में कितने हस्ताक्षर किए याद. किसने हस्ताक्षर किए याद. मैं इस अग्रीमेंट में सुरेश प्रसाद को पर्सनली जानता हूँ. सुरेश प्रसाद जिसको लेकर आए थे उसने कहा कि मेरा नाम सूरज भदानी है और वह भी बोले कि मेरा नाम यही है. सूरज भदानी का आइडेंटिफिकेशन का दस्तावेज मैंने मांगा था लेकिन उन्होंने नहीं दिया. ऐसी बात नहीं है कि सूरज भदानी ने हस्ताक्षर नहीं किया था और किसी और ने उनके बदले इस अग्रीमेंट में हस्ताक्षर किया था. गवाह का कहना है कि मैंने सूरज भदानी को देखा जो कि रामगढ़ पर एडवोकेट के यहाँ आया जाया करते थे. रामेश्वर राम सेवक एडवोकेट के यहाँ आया जाया करते थे. गवाह को पढ़कर सुना.
Even the plaintiff has not mentioned about the presence of PW4 at any stage, so far as at any stage for that, or money receipt, or for execution of the agreement of sale, except PW4, who says that I was present. None of the witnesses have stated about his presence, or whispered about his presence, or even whispered that he was the person who took the document for typing and then it was typed. None of them have stated anything. Now you come on readiness and willingness. The trial court has committed an error while recording readiness and willingness by referring to the money related to money receipt. But readiness and willingness has to be proved after the agreement regarding payment of the remaining amount. And I hope you must have seen the judgment that merely a statement that you are ready and willing is not sufficient. So, what evidence have you led with regard to readiness and willingness with respect to performance of the remaining part?
Milord, I have stated.
Admission will not cut much ice because admission will not give you an edge in this.
I have stated with respect to, first of all, the case itself has been filed within the limitation period.
There is no, the 3 years limitation is there. There is no
Yes.
problem on it.
Without, after the limitation period it has not been filed. Secondly, there was a notice that was sent, though it has not been brought on record, and by client suggests that informed me that the documents were produced. It was submitted before the court below, but it was not marked as an
It
exhibit.
is not available in the record. There is no whisper that the original of this document has been produced.
Leadership,
There is no whisper about
एक
it.
order है 5/2008 का in the LCR. List of the documents filed by the plaintiff, same was kept in the safe custody. So there was
Where is the list?
that is not there. It is not there. It is not visible.
It is your
I find-
document. You should have given a list that this is the list of documents filed.
And the same is there.
No, you
also.
must be having that list.
That
Okay,
is-
you have filed it with the list of.
Yes, it is there. The order reflects that a list was filed by the plaintiff and it was kept in the safe custody. I say I filed the list. I say that there was a notice that was
We will
filed.
not assume.
Neither the list is there, neither nor the notice is there, though the order reflects that there was a list which was filed by the plaintiff. But it is not traceable in the record. And also reflected in the Shiristadar report dated 5/2008 that a list was filed and the documents and the
So
list
where
was
have you stated that you filed a list of documents which contain these documents? Where is your statement? And where is that list? When you submit original documents before the court, you maintain a list for yourself. Where is it?
list is not there. But it reflects in the order that there was a list and the documents that were submitted, those were submitted before the court below and it was kept in the safe custody. Now which safe custody it is, Milord? Because neither the list nor the documents, nothing is visible in the incident. And that's why I have filed the IA for bringing on record the additional
No,
document.
this is not bringing on record additional document. This will be a different petition. If there is a document already on record and then it could not be marked, it is not something bringing additional document on record. You have to say that it has already been executed. It is already there and it could not be marked. So, this is not additional evidence. Did it amount to additional evidence?
No, the evidence was, we have stated in the IA that it was filed before the court below, it was not marked as an exhibit. Hence, the photocopy that I am holding, having the possession of, I am filing that. And readiness and willingness, leadership, I was never cross-examined on that. No
Need not
objection
be.
and no issue
Need
has
not
been
be.
framed.
Need not.
And no issue
You
has
are
been
joining
framed.
issues on that. You are joining issues on that. You are pleading that you were ready and willing to perform merely because there is no specific issue framed on that. That is not fatal to the case. Parties know their respective cases. You have to plead and prove readiness and willingness. You know about it. You have pleaded also, right? In whatever manner you have, you could. And then there is no evidence further. Nothing.
There is a judgment to that extent also, leadership, that when there is a case of specific performance, the issue with respect to readiness and willingness has to be framed by the court below, and then it has to be adjudicated. Last two.
The sign. When was the suit filed?
2007.
Date.
30th of November 2007.
Sorry?
30th of November 2000.
This page number 20 of your document, page number 20 of the document which you have filed, is it AD?
Supplementary.
The supplementary affidavit. Is it AD?
This is the receiving
Receiving?
amount.
Receipt.
Receipt.
Postal receipt issued.
Postal receipt
Postal
of dispatch.
Yes.
Does it have a date?
No, it doesn't.
Then even if we take your additional evidence, how do you prove the dispatch? Because it was recorded in the order also, and you are put to notice to respond to this.
No, no date is mentioned. I cannot include. There's no mention of
There
any
is no
date.
seal as well. Seal of the postal.
Seal, let's forget it. At times it is not there. We do not know.
Generally, seal are put. And in the print also, there is no mention of the postal receipt number.
And certainly it is not AD.
No, it is not. It is the postal receipt.
Yes, you are placing this down.
And 8 and 9.
Para?
8 and 9. Now the findings and the reasoning given by the learned trial court refusing to pass a decree for specific performance is concerned, it appears that though there was no specific issue framed by the learned trial court on readiness and willingness on the part of the plaintiff, the trial court has given the finding on the same and has non-suited the plaintiff by observing that the plaintiff was not having sufficient funds to make the full balance consideration on or before 12/1/2006. Such a finding could not have been given by the learned trial court without putting the plaintiff to notice and without framing a specific issue on the readiness and willingness on the part of the plaintiff. There must be a specific issue framed on the readiness and willingness on the part of the plaintiff in a suit for specific performance, and before giving any specific finding, the parties must be put to notice. The object and purpose of framing the issue is so that the parties to the suit can lead the specific evidence on the same. On the aforesaid ground, the judgment and the order passed by the learned trial court dismissing the suit and refusing to pass the decree for specific performance of the agreement to the suit and to sell confirmed by the High Court deserves to be quashed and set aside, and the matter is to be remanded to the learned trial court to frame the specific issue with respect to the readiness and willingness on the part of the plaintiff. On remand, the parties be permitted to lead the evidence on the readiness and willingness on the part of the plaintiff and perform this part of the contract. More particularly, whether the plaintiff was ready and willing to pay the full consideration and whether the plaintiff was having sufficient fund and or could have managed the balance sale consideration. In view of the above and the reasons stated above, the present appeal succeed in part. The impugned common judgment and order passed by the High Court and the judgment and the decree passed by the learned trial court dismissing the suit referred by the plaintiff for specific performance of the agreement to sell are hereby quashed and set aside. The matter is remitted back to the learned trial court to decide and dispose of the suit afresh in accordance with the law and on merits. The learned trial court is directed to frame the specific issue on the readiness and willingness on the part of the plaintiff to perform this part of the contract, and thereafter the parties may be permitted to lead the evidence on the readiness and willingness on the part of the and decide and dispose of the suit on merits and on the basis of the evidence that may be led. The aforesaid exercise may be completed by the learned trial court on remand within a period of 12 months from the date of receipt of the present order. Both these appeals are accordingly allowed to the aforesaid extent. In the fact and circumstances of the case, there shall be no order as to pass.
So in absence of specific issue, this finding is permissible.
And ladyship, one judgment because he has continuously been saying and denying his signature over the documents and did not produce even to the handwriting expert on his deposition. He has stated that the handwriting, it may be sent to the handwriting expert. Handwriting
was sent to the handwriting.
Yes, handwriting expert asked for his specimen for that period of time in the official records. He never produced, and he has been.
Was he ever directed to produce it? It is, you see, once the signature is sent for handwriting expert, and thereafter the opinion of the handwriting expert comes. Then, if more specimen is required, then who has to take steps for that? Either the court would ask, or he will suo moto give his further specimen, or you will ask. And further, there is one more thing. In your evidence, it has come that he was a partner of some firm in which you are also the partner.
Yes,
Very small.
very sure.
Right? So you are well known to each other. You are joining hands in another partnership firm. So it's not that you have no access to his admitted signatures.
Ladyship, the
You have a-
onus is upon the defendant who is alleging that the documents are forged and fabricated one. He is the person who could have brought the documents and
No,
to show.
you see, handwriting expert did not take to a conclusion that it is the signature or not the signature of the defendant. And ultimately, the court has taken into consideration the oral evidences to come to a finding that you have not been able to prove the agreement. This is what the court has done. According to you, the oral evidence were well substantiated, and they were cross-examined also. But at the same time, one of the witnesses was not examined, who was alive.
Yes.
Any explanation for non-examination?
He was his examination in chief was by leadership, but he did not turn up for his cross-examination. So he
So
was expunged.
virtually he was not examined.
Yes, he was examined by him, and he was expunged.
Yes, what do you say? इनका submission पहले लिखा.
ये judgment के leadership upon the burden of para 89 is relevant. 2025. Burden of proof is upon the defendant if he alleges the forged and fabricated agreements.
देखिए. This appeal has been filed against the judgment and decree dated 31/2023, within bracket decree signed on 4/2/2023, passed by learned civil judge within bracket senior division bracket 2 Soman 3, Jamshedpur, entitled suit number 112 of 2007, registered as TPES 112 of 2007, whereby the suit seeking specific performance of agreement dated 1/6/2007 has been dismissed. The learned counsel for the appellant has placed the plaint and the written statement and has submitted that the defendant was the power of attorney holder of the owners of the property to the extent of 1/5 share,
4/5.
to the extent of 4/5 share, and had entered into the agreement of sale with the plaintiff in the capacity or power of attorney she has also submitted that the general power of attorney with respect to the suit property was executed by Rabindranath Chakravarti, Virendranath Chakravarti and Mrs. Leela Chakravarti, wife of late Sachinnath Chakravarti, in favor of the defendant, and was registered in the office of Kolkata Registrar of Assurance, being deed number Roman 4 4492, Roman 4 4493 and Roman 4 4494 on 4th of October 2004, and one general power of attorney by Ahindranath Chakravarti in favor of the defendant was executed before the solicitor and notary public courts, courts 2 Princess Street at Kolkata, at Kolkata, no?
England.
No. Notary public court CODES 2, Princess Street, Truro Cornwalls TRI.2EZ, England, on 4th of October 2004. And it was stated in the plaint that copies of the power of attorney was handed over to the plaintiff by the defendant as reference, but the original was handed over to was retained by the defendant. The agreement of sale, the value of the suit property as per the agreement of sale was 40 lakhs, and the agreement was entered into on 1/6/2007. Which was typed in presence of the witnesses. And pursuant to the said agreement of sale dated 1/6/2007, the defendant received a sum of rupees 9,75,000 from the plaintiff as advance amount, for which money receipt was issued, which was duly acknowledged and admitted by the defendant in the agreement, as well as by granting money receipt to the plaintiff, which was duly typed and signed by the defendant in presence of the witnesses. It was agreed that the final sale deed will be executed within 30 days from the date of the agreement, and the remaining balance amount of rupees 30,25,000 was to be paid. It was also agreed that if the defendant failed to register the deed of sale within the stipulated period, the plaintiff will be at liberty to enforce the specific performance of agreement by instituting legal proceedings. And in that event, the defendant will be liable to pay the cost and expenses for the proceedings. It was the case of the plaintiff that, in accordance with the agreement dated 1/6/2007, an amount of rupees 9,75,000 was paid in good faith with respect to the suit property. And the plaintiff waited for a stipulated period of 30 days, and the plaintiff never doubted the bona fide of the defendant in abiding the terms of the said agreement in question, as good relation existed between the parties, and accordingly the plaintiff waited for the stipulated period 30 days. But after expiry of the said stipulated period, the plaintiff approached the defendant and requested several times for execution and registration of the said deed of the suit property in favor of the plaintiff on receipt of the balance consideration amount of rupees 30,25,000, while the defendant on and from 7/7/2007 started avoiding to accept the balance consideration amount from the plaintiff and refused to execute and register the sale deed. Although the plaintiff was all along ready and willing to perform his part of the contract arising out of the agreement dated 1/6/2007, and had performed his part of the contract arising out of the agreement dated 1/6/2007, and in accordance with the said agreement, he has performed ये page number 8 का bottom पढ़िए.
Perform a considerable part of it.
Performed a considerable part of it. बस इतना ही.
No. And it is certified performance.
हाँ, आप हमको दे देंगे. It was for the case of the plaintiff that ये agreement कौन सा exhibit है?
Exhibit 1.
हाँ. It was for the case of the plaintiff that the plaintiff served a registered legal notice upon the defendant requesting him to perform his obligation by executing the deed of sale. And the plaintiff, on receipt of the balance consideration amount, in favor of the plaintiff on receipt of the balance consideration amount, and the notice was dated 27/8/2007, but the defendant deliberately avoided to perform his part of the contract, and consequently the suit for specific performance of contract is filed. As per the plaintiff, the cause of action arose when the suit property was as per the plaintiff, the suit property was kept locked with keys of the front room with a caretaker or looking after the house. As because the co-sharer of the suit property, namely Rabindranath Chakravarti, Virendranath Chakravarti, Leela Chakravarti, Leeta Chakravarti, आगे 9 का last.
Next.
Leeta Chakravarti, wife of Satyamnath Chakravarti, and Ahindranath Chakravarti have not been living in the suit premises. It was therefore the case that the suit property was lying. The caretaker informed the plaintiff over telephone that the suit property was lying vacant, and on the evening on 10/11/2007, the defendant number 1 came with 3 to 4 persons to the suit premises and threatened the caretaker to leave the suit premises with dire consequences. Because the defendant had purchased the suit property below structure standing thereon and will dispose of the same. The learned counsel has submitted that the agreement was exhibited as Exhibit 1. she has further submitted that the legal notice and the registered AD and AD of the registry notice was filed before the court, but inadvertently the same was not exhibited, and consequently an interlocutory application has been filed seeking to adduce additional evidence, and a photocopy of the legal notice and the AD has been annexed along with the interlocutory application, as the original was still lying with the concerned court. She has referred to order dated
5th of February 2008.
sorry 5th of February 2008, wherein it has been recorded that the plaintiff filed the documents along with the list.
Order
List
says
of the documents
certain
filed.
documents were filed.
And the same has been kept in safe custody.
Certain documents along with the list.
List
No,
of the documents filed by
With that certified copy order sheet is also there.
in between the first and second page of the claim.
Order dated
Order number 8, 5th February 2008. Learned counsel files attendance along with deficit court fee of rupees 50,000 and certain documents as per list and the petition paying therein to keep the same in safe custody.
And also reflected in the Shirestadar report dated 5 February, which is claimed in the claim 1 half.
Again, learned counsel files attendance along with deficit court fees of rupees 50,000 only.
Certain documents as per list.
She has submitted that on 5/2/2008, deficit court fees was filed with certain documents as per list, with a petition praying therein to keep the same in safe custody. She submits that on the same day the case was admitted and the petition to keep documents in safe custody was allowed, and the documents were directed to be kept in the safe custody under envelope furnished by the plaintiff. However, during the course of hearing, the learned counsel has however, during the course of hearing, it appears from the interlocutory application that the date of furnishing the additional documents, which is sought to be adduced in evidence at this stage, has not been mentioned, nor the list of documents which was furnished on 5/2/2008 has been placed on record by the learned counsel seeking to adduce additional evidence. The learned counsel has submitted that the learned trial court did not frame any issue on readiness and willingness on the part of the plaintiff to perform the contractual obligation as per the agreement of sale, and has simply framed an issue as to issue number 3 as to whether the plaintiff is entitled to a decree for specific performance of contract, and also further issue as to whether the suit was barred under the provision of Specific Relief Act and CPC. Having not framed any issue, the learned court came to a finding that the plaintiff was not ready and willing to perform his part of the contract. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court, reportedly 2022 SCC Online 1545, and has submitted that in the same case also, the trial court had framed only 2 issues. One, whether the plaintiff is entitled to a decree of specific performance as sought for, and 2, whether the plaintiff is entitled to return of advance paid, and if so, its quantum. It submits that the Honorable Supreme Court was of the view that the finding regarding readiness and willingness to perform the part of the agreement could not have been given in absence of any specific issue framed by the trial court, and the matter was ultimately remanded to the trial court to dispose of the suit afresh by framing the issue regarding readiness and willingness to perform the contract. The learned counsel submits that on this score the matter is fit to be remanded to the court concerned. The learned counsel has also submitted that the question of remand would arise only when the other findings which have been recorded by the learned court are set aside. Correct? She has submitted that the learned court has recorded a finding that the plaintiff has not been able to prove the execution of the agreement dated 1/6/2007. She has submitted that the defendant had raised a plea that his signature on the agreement was forged and fabricated, and his signatures were also sent for examination by a handwriting expert. But the handwriting expert could not give a definite opinion with regard to genuineness of the signature and asked for furnishing fresh further signatures, but the defendant did not take any steps for the same, and consequently the plea that the signature was forged and fabricated could not be proved by the plaintiff. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2025 bracket close.
Also,
Who has to prove?
2025 volume 3 SCC 286 para
Bracket 2025 bracket close 3 SCC 286 para
PG
89 to submit that when fraud and misrepresentation are alleged by defendants, the burden of proof lies upon them to substantiate such claim. Yes, she has submitted that the defendant failed to prove the allegation of fraud, as he had denied his signature on the agreement by leading credible evidence to support this allegation.
Ladyship, I have also been acquitted in the criminal case which was filed by the defendant upon me for this forged and fabricated document and signature, for forging his signature.
The learned counsel has also submitted that a criminal case was instituted by the defendant against the plaintiff in connection with the same agreement which was alleged to be forged and fabricated, and the appellant has been acquitted in the same case.
Second, supplementary affidavit.
She has submitted that this document has also been sought to be brought on record by way of additional evidence, and this is on account of subsequent development, inasmuch as the acquittal order is dated 11th of May 2023. अब ये सूट कब का है?
2007.
हाँ. And the judgment of acquittal has been passed after the impugned judgment. For particular paragraph,
30th of January 2020.
it was sent for handwriting expert examination.
Everything has been considered, Ladyship, and their own witness PW2 has said that it was signed by the defendant himself. On the deposition of PW2, who has not been declared hostile by the court.
PW2 is who?
Advocate Shankar Singh.
He has not been examined in this case.
Shiv Shankar Singh is PW3.
PW3 here.
Yes.
The learned counsel has submitted that the court, while acquitting the defendant in the criminal case, has referred to the evidence of PW2 Shiv Shankar Singh, who was examined as PW2 in the criminal case and was examined as PW3 in the suit. And PW2 in the criminal case had stated that both the parties had come to him and agreement for sale for superstructure was prepared in his presence. And this witness had put signature on each page of the agreement as identifier. And this witness also stated that rupees 9,75,000 was given to the informant by the accused in presence of the witnesses. The learned counsel has submitted that there is enough evidence, oral evidence on record, to substantiate that the agreement was duly signed between the parties. And the witnesses to the agreement, one of the witnesses to the agreement had expired, and so far as the other witness is concerned, his evidence in chief was filed, but he did not turn up for cross-examination, and therefore his evidence could not be taken into consideration. The learned counsel has submitted that other witnesses to the agreement have deposed in favor of the plaintiff, and they were also duly cross-examined. And considering the fact that the allegation of forgery has been turned down by the criminal court, in which one of the common witnesses, namely Suresh Kumar Singh, Shiv Shankar Singh, was also examined. The finding of the learned court that the plaintiff could not prove the agreement is not sustainable in the eyes of
Even if we go by section 73 of the Indian evidence act. It says that the court has the power कि parties को sign करा करके court can itself look into whether the signature is forged or not. I read that part. Section 7.
The Learned Council has also submitted that even the court had the power to compare the signature on the face of it. But even this power has not been exercised by the level concerned. Once the handwriting expert declined to give any specific finding while comparing the signature. जब वो नहीं दे पाया तो कोर्ट कैसे दे देगा?
ये भी तो नहीं बोला कि forged है.
वो तो
बोला
कोई
कुछ incline कर रहा है, कुछ because of the time there is some differences. So एकदम exact opinion देने के लिए उस time का signature.
ठीक. Where is the agreement? Agreement is dated
1/6/2000.
Exhibit 1. Right?
Exhibit.
The Learned Council for the appellant has placed the agreement of sale which relate only to superstructure. Which is dated 1st of June 2007 and refers to the power of attorney which has been mentioned above. And has submitted that as per the agreement itself, the consideration was 40 lakhs, 9,75,000 was paid in advance. And money receipt was issued. And as per the first clause of the agreement, the defendant had undertaken to execute and register proper sale deed of the superstructure standing over the property within 30 days from the date of the agreement, and at that time the plaintiff shall pay the remaining amount of rupees 30 lakhs 25,000 to the defendant and the defendant undertook that the scheduled property was free from all encumbrance and prior to day he has not transferred the property in any manner in favor of any person or firm. The Learned Council has submitted that the defendant in the written statement has simply stated that the sued property was transferred to third person, but neither the name nor the details of such transfer was mentioned in the written statement. However, during evidence, the defendant had deposed that the sued property was transferred by registered deed dated. आपका registered deed कितना था जो आप transfer किया?
It was 2005.
Deed number.
पैरा 19 में था ना खाली डेट था ये नंबर में
Date था.
सिर्फ डेट था 2005 समथिंग पैरा 19
आप बताइए, आपने रजिस्टर्ड डीड का डेट बताया था? डीड नंबर एंड डेट. Had only given the date of the transfer, which was 2005.
2005
Which was
he says that
2005.
prior to the execution of the sale agreement for sale the property was sold to some other person by sale
Yes.
date.
He had stated in his written statement that prior to agreement of sale, the property was already sold to third party, but no foundational detail was mentioned there. However, during his evidence, he has given the sale deed number and the date, but did not produce the same before the court.
Sale date number शायद नहीं है।
Sale deed number नहीं है. I've seen it somewhere.
It was sold on 17th of May 2005. It has come in the imperial order. Page internal page 13.
17th of May 2005.
2005.
Or deed number?
The deed number is not mentioned in the imperial order.
Sold on 17th of May 2005. It also transpired during the course of hearing that the plaintiff, in his evidence also, has stated that the defendant, that during the pendency of the suit, the defendant sold the property in favor of MS Vinayaka Homemakers, and defendant was a partner in the said firm, and the said property was also sold in favor of Sunita Seth, wife of Sunil Kumar Seth, by means of a registered sale deed bearing number 3124 dated 22/5/2009, and she got her name mutated in the records of Tata Steel Limited and had constructed a multi-storied building on the same. However, during the course of argument, the present counsel has fairly submitted that the purchaser of the suit property has not been made party in the proceedings. She has submitted that there is no need to make the purchaser of property party, inasmuch as, and for that purpose, she has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2020 bracket close 13 SCC 773, and has submitted that it is for the plaintiff to decide as to who would be the party in a proceeding, and merely because the subsequent purchaser was not party in the proceeding, the same is not fatal notice. She has submitted that in the same case, in spite of an interim order passed by the court, the suit property was transferred in favor of third party, and the trial court, at the instance of the third party, had allowed the petition under Order 1, Rule 10. The said order was set aside by the High Court in writ petition, against which the matter was before the Honorable Supreme Court. The appellant before the Supreme Court was the third party, whose name was ultimately deleted by virtue of the order passed in the writ. The learned counsel has submitted that the position is different when the plaintiff files an application for imprisonment, but the court cannot force the plaintiff to make third party as party in the proceedings. She has submitted that impeding third party as party in the proceedings would change the scope of the suit, and therefore, in order to grant relief to the plaintiff, there was no need to join the third party in the proceedings.
And further, Leadership, the subsequent sale was also barred under Section 52 of the Transfer of Property Act because this instant suit was pending, and during the pendency of the suit,
The learned counsel has further submitted that the subsequent sale deed was barred under Section 52 of the Transfer of Property Act. What does it say?
it says that
Okay, Transfer of Property Act. Okay, we'll take it.
doctrine of mispendency.
The learned counsel has submitted that the subsequent suit would be, the subsequent transfer would be governed by doctrine of mispendency. However, as recorded in the impugned judgment and not disputed by the learned counsel for the appellant, that it was submitted by the plaintiff themselves that the suit property was transferred to Sunil Kumar Seth by way of registered SAD number 312
Sunita Seth.
Sunita Seth by virtue of SAD number 3124 dated 22/5/2009, and this was preceded by another SAD. However, the details and the date of that SAD has not been brought on record. Correct? The learned counsel has, in this context, the learned counsel has submitted that the judgment passed by Honorable Supreme Court in Kasturi versus in the judgment reported in bracket 2005 bracket close 6 SCC 733 has been followed in the aforesaid judgment reported in bracket 2020 bracket close 13 SCC 773, and the judgments passed in the case reported in bracket 2024 bracket close 8 SCC 83, and the judgment passed reported in bracket 1953 bracket close 2 SCC 509 has no applicability in the present case. That's all. Yes, what do you have to say?
The evidences and the pleadings, as also the documents produced by the plaintiff, does not prove their case matter. First of all, the defendant has straight away denied his signature over the agreement. The witnesses of the plaintiff could not prove the.
You were the defendant.
I was the defendant. I was the
Who
sole
was to
defendant.
prove that it is not your signature?
My lord, the defendant denied his signature, that there was no signature of his.
Who was to
The
prove that?
My lord, in my deposition, I straight away denied that it is not my signature.
That's right. When you say that it's not your signature, then who has to take steps to ensure?
Steps
Were taken, but you did not give any further
step was
signature.
taken by the plaintiff that these compliances are to be fulfilled to ensure that signatures
You
are.
see, you sent your sample for examination. The report was they need more sample. You did not furnish it.
No one did take any further step.
You see, as long as the onus is on you to prove
My-
fraud, so it was you who were to take the steps.
Witnesses produced by the plaintiff even failed to identify the defendant, my lord. as it was me who put my signature in their presence. Specific questions were asked by the cross examination and they denied.
How many witnesses are there to the agreement?
Two. Vinod Singh
witnesses.
and Arvind Singh. Vinod Singh died.
That's right, you forget about them.
Arvind
In
Singh,
the record, how many witnesses have come to support the agreement?
some have come stating that agreement and money receipts were signed in their presence.
You
Though
don't
there
come
was
to the
no
money
such-
receipt. I'm talking about only the agreement because the agreement is itself talking about payment. So forget about the
So
money
in the
receipt.
agreement there is a signature of plaintiff, defendant, witnesses.
Plaintiff has been
parties.
examined.
Plaintiff has been examined.
Have you cross-examined the plaintiff on this?
Money.
Plaintiff is
Madam,
PW1.
a question was asked.
Plaintiff is PW1.
PW1.
Correct? Okay. What is your cross-examination on the signature? बताइए पैरा नंबर बताइए
पैरा नंबर 35 है।
आप 29 से पढ़िए ना क्रॉस एग्जामिनेशन
शपथ पत्र जो मेरे तरफ से दाखिल हुआ है उससे कुछ पढ़े हैं। मुझे अंग्रेजी काम चलाने लायक पढ़ने के लिए आता है। शपथ पत्र में जो मेरे तरफ से दाखिल किया गया उसके सारे तथ्यों की जानकारी मुझे है। सूट प्रॉपर्टी दीनानाथ चक्रवर्ती के नाम से टाटा स्टील द्वारा आवंटन किया गया। दीनानाथ चक्रवर्ती के 5 बेटे और 3 बेटी थे जो क्रमशः सो हैं। लड़कियों का नाम भी याद नहीं। 5 बेटे और 3 बेटी की का उस जमीन पर बराबर का हिस्सा था जिसके संदर्भ में मैंने इकरारनामा किया था। 3 बेटियों ने अपना हक छोड़ दिया था लेकिन इस संदर्भ में कोई दस्तावेज देखने का मौका मुझे नहीं मिला। जिस दिन मैंने इकरारनामा किया था उस दिन वह जमीन दीनानाथ चक्रवर्ती के बेटा बेटी के नाम से टाटा स्टील के रिकॉर्ड में दर्ज थी। यह जमीन किसको लीज होल्ड जमीन थी। मैंने सूरज कुमार बदानी के साथ इकरारनामा किया था। सूट प्रॉपर्टी का कोई विक्रय केवल मैंने सूरज कुमार बदानी के नाम से नहीं देखा था। मैंने सूरज कुमार बदानी के नाम से पावर ऑफ अटॉर्नी देखा था। सूरज कुमार बदानी का पावर ऑफ अटॉर्नी रजिस्टर्ड था। उस पावर ऑफ अटॉर्नी में जो पावर दिया गया था वह मैंने देखा था। मैंने उस पावर ऑफ अटॉर्नी का जेरॉक्स कॉपी न्यायालय में दाखिल किया। यहाँ ये बोल रहे हैं आया नहीं। यह कहना सही है कि मैंने इकरारनामा रविन्द्रनाथ चक्रवर्ती, वीरेंद्रनाथ चक्रवर्ती, रीता चक्रवर्ती तथा अंजनाथ चक्रवर्ती के साथ किया। यह कहना सही है कि इस बात में चारों व्यक्तियों को पार्टी नहीं बनाया
क्या मैंने
35। यह कहना सही है कि मैंने इकरारनामा रविन्द्रनाथ चक्रवर्ती, वीरेंद्रनाथ चक्रवर्ती, रीता चक्रवर्ती तथा इंद्रनाथ चक्रवर्ती के साथ किया। यह
सेल अग्रीमेंट if we see शुरू में इनका नाम थ्रू पावर ऑफ अटॉर्नी सेल अग्रीमेंट जो था पहले इसका नाम था थ्रू पावर
बट इसका नॉट एक्सप्लेन्ड फ्रॉम द एविडेंस में। यह कहना सही है कि इस बात में उक्त चारों व्यक्तियों को पार्टी नहीं बनाया गया। मैंने उक्त चारों व्यक्तियों को कोई भी पैसा अदा नहीं किया है। ऐसी बात नहीं है कि मैंने इकरारनामा दिनांक 1 जून 7 के आधार पर यह पेश किया, वह जाली है। विनोद कुमार सिंह और अरविंद कुमार सिंह ने गवाह के रूप में उक्त इकरारनामे में हस्ताक्षर किया था। विनोद कुमार सिंह की मृत्यु हो गई है और अरविंद कुमार सिंह को गवाह के रूप में प्रस्तुत कर सकता हूँ। ऐसी बात नहीं है कि जिस इकरारनामा के आधार पर मैंने यह पेश किया उस पर सूरज कुमार बदानी का जो हस्ताक्षर है वह जाली है। दिस वाज द सजेशन गिवन। ऐसी बात नहीं है कि मैंने सूरज कुमार बदानी को गलत तरीके से पैसा वसूलने के लिए झूठा केस किया है।
With respect to the cross-examination of PW1, I just know. With respect to the cross-examination of PW1, the learned counsel for the defendant has submitted that a suggestion was put to the plaintiff PW1 that the signature on the agreement was forged. That's all. यही examine cross examination और
And
बताइए.
the other witness, it was PW to mark the agreement for sale as exhibit one. Sudev Chandra Mandal, he was the typist.
The learned counsel has submitted that the agreement was exhibited by PW2 Suresh Chandra Mandal, who was Sudev Chandra Mandal, who was the typist.
And when he was put to cross-examination on the signatories or to the witnesses about the names of witnesses to the agreement, he denied to have remembered the names. Question number 4. टाइप होने के बाद के वादी सुरेश प्रसाद और प्रतिवादी का नाम याद नहीं है. दोनों ने मेरे सामने हस्ताक्षर किया था इकरारनामा पे. उस एग्रीमेंट के गवाह भी थे. कौन थे याद नहीं. Agreement notary हुआ था.
He submits that during the cross-examination, though he has stated that the plaintiff and the defendant had put their signature on the agreement in his presence, but he could not recollect as to who were the witnesses to the agreement. And he could not recollect as to whether the agreement was notarized or not. Bas?
Question number 6 and 7 will also be relevant. Wherein it was put that मैं कोई इकरारनामा या दस्तावेज टाइप करता हूँ उसका मैं कोई रजिस्टर.
इसका क्या relevance?
कि इनको ये
कोई ऐसा register नहीं maintain करता.
इनको ये एग्रीमेंट पर्टिकुलरली कैसे याद. जबकि वो बोलते हैं कि मैंने किन दस्तावेज को टाइप किया तो याद नहीं है. और ये भी बोलते हैं कि सुरेश प्रसाद को 30 साल से जानते हैं. He was very much familiar with the plaintiff for the last 30 years.
During his cross-examination, he has also stated that he did not remember as to how many documents relating to Suresh Prasad he had typed, and he has known Suresh Prasad, the plaintiff, for last 30 years. That's all.
This is with regard to agreement. So far as signature on money receipt and money receipt itself is concerned, my lord, it has not been properly proved, my lord. It was proved by a person who was a stranger to the transaction.
The learned counsel for the defendant has also submitted that so far as the money receipt is concerned, the same was also not duly proved by the persons who were party to it. And it was exhibited by, it was proved by, it was exhibited by the advocate clerk. And
That's clerk of advocate, not PW3, my lord. Advocate in this.
advocate clerk of
Another
advocate who was not examined as witness. Criminal case के बारे में क्या बोलेंगे?
Well, finding of criminal case does not bind civil court proceeding. Same is the position vice versa. This is the latest position, my lord.
But if the same witness is deposing differently in criminal case,
The degree of proof is different in both the cases, my lord. I would like to place a reliance on the judgment in this regard. My lord, of the Honorable Supreme Court.
the learned counsel has submitted that so far as the acquittal of the appellant in the criminal case is concerned, the same has no bearing in this case.
Paragraph 18.
He has referred to the judgment passed by Honorable Supreme Court reported in
2010 volume 8 SCC
2010 volume 8 SCC
775.
775 para number
18.
18.
Yes.
he has submitted that it has been held that the finding of fact recorded by civil court do not have any bearing so far as criminal case is concerned and vice versa. The standard of proof is different in civil and criminal cases. In civil cases, it is preponderance of probabilities, while in criminal cases, it is proof beyond reasonable doubt. He has also submitted that it has been observed that there is neither any statutory nor any legal principle that finding recorded by court either in civil or criminal proceeding shall be binding between the same parties while dealing with the same subject matter. Both the cases are to be decided on the basis of evidence adduced therein. However, there may be cases where the provisions of section 41 to 43 of the Evidence Act 1872 dealing with the relevance of the previous judgment in subsequent cases may be taken into consideration. कब डिपोज किया था वहाँ पे PW2?
That I was looking for in the judgment itself, which was produced as an additional evidence. Date is not mentioned.
The learned counsel has also submitted that the deposition of PW2 was also not exhibited before the learned trial court, nor his deposition has been placed on record by way of additional evidence before this court. He has submitted that the evidence of one or the other witness in criminal case, if at all, has to be taken into consideration. The entire evidence has to be taken into consideration, including the cross-examination. Merely because the finding has been recorded in the criminal case, the same will have no bearing in the civil case unless the deposition itself is exhibited and presented. यही है ना principle? तो कौन बहस करेगा?
This is my. I have stated this in my reply, madam. To the additional evidence.
He has referred to the reply filed to the petition seeking additional evidence.
Because I would like to place 2-3 pages of the improved judgment, which was since entire judgment has not been placed yesterday.
Yes. नहीं, ये we'll come to the improved judgment. अच्छा ठीक है, पहले आप इसको complete.
And before I start, I would like to place reliance on order 14 of CPC, which deals with framing of issues. Why a particular issue was not framed as to the readiness and willingness. The plaintiff himself admits that he has filed original documents on 5th of February 2008, by which date issues were not framed. And for framing issues, it is a requirement that it has to be framed on the basis of pleadings or documents or considering both. Since there was no document, particularly the legal notice, which is a step towards which is a step showing readiness and willingness. Since it was not on record, so particular issue with regard to readiness and willingness was not framed, and since there was no statement as to the
When was the issue framed?
Melody, it was framed in 2008 itself.
Prior to filing of documents or after filing?
After. It was
So the
framed
documents were available.
but only agreement was available, madam. Since no legal notice was available, no.
Without legal notice, one cannot prove readiness and
It
willingness.
was
Without legal notice, can anybody prove readiness? Because the case was filed soon thereafter.
exactly, madam.
It is not. They did not wait for 3 years.
So,
3 years
so-
का limitation नहीं माना.
Showing readiness and willingness, there is only one paragraph, madam. Para 14.
One para is one line is sufficient.
But no statement with regard to
That is a
availability
separate-
of fund. There is
That
no
is a separate.
No,
That is
no,
a
there
separate.
is,
But therefore, since no issue was framed, they did not even lead evidence to that effect. So you want to say that there was no pleading, so they could not have led any evidence.
yes, ma'am. For framing issue, there has to be pleading. If there is no pleading, no issue will be framed on that particular issue. There was no pleading to the effect that plaintiff was having sufficient fund or he is ready to arrange the balanced fund. So no issue particular with regard to that particular.
The learned counsel for the respondent has referred to order 14.
Order 14.
Rule
Madam, rule 3.
Rule 3 of CPC.
Materials from which issues may be framed.
Sorry.
Materials from which issues may be framed.
To submit that the materials from which issues are to be framed are the plaint and the written statement, and also the documents which are produced. The learned counsel submits that since the legal notice was never produced, the readiness and willingness was not available, and therefore there was no need to frame any issue regarding readiness and willingness. He has also submitted that since only a bald statement was made that the plaintiff was ready and willing to perform his part of the contract without any further pleading as to the availability of the fund / source of the fund. Therefore, on such vague pleading, no issue of readiness and willingness to perform the part of the contract would have been framed. The learned counsel has submitted that by now it is well settled that readiness and willingness to perform the contract with some details is required not only to be pleaded but also to be proved.
May I place judgment on that?
He has relied upon the judgment passed by Honorable Supreme Court reported in
1995
95 appointment.
उसके बाद उसी पे रिलाई किया गया है लेटेस्ट
1995
वॉल्यूम 5 एससीसी 115
Volume 5 SCC 115
पैरा 5
Para 5. And further, yes. And further,
it is
एक और judgment भी बताइए.
मैडम लेटेस्ट 2023 and 24
2023
23 volume 11 page
Volume
775
11 SCC
page 775
page 775 para number
para
24 and 2024
SCC online 358
SCC online 3586
para 8 and 10
para 8 and 10 पैराग्राफ लिखने में गड़बड़ नहीं करेंगे है ना.
the first I would like to place 95 here.
$95
Para 5
yes $95. Pardon?
It is settled law that remedy for a specific performance is able to remedy and is in the discretion of the court, which discretion requires to be exercised according to settled principles of law and not arbitrarily as enumerated under section 20 of the Specific Relief Act. Under section 20, the court is not bound to grant the relief just because there was a valid agreement of sale. Section 16C of the Act indicates that plaintiff must plead and prove that he has performed or has always been ready and willing to perform the essential terms of the contract which are to be performed by him. Other than those terms, the performance of which has been prevented or waived by the defendant. The continuous readiness and willingness on part of plaintiff is a condition precedent to grant the relief of a specific performance. This circumstance is material and relevant and is required to be considered by the court while granting or refusing to grant the relief. If the plaintiff fails to either cover or prove the same, he must fail. To adjudge whether the plaintiff is ready and willing to perform this part of the contract, the court must take into consideration the conduct of the plaintiff prior and subsequent to the filing of the suit, along with other attending circumstances. The amount of consideration which he has to pay the defendant must of necessity be proved to be available. Right from the date of execution to the date of the decree, he must prove that he is ready and has always been willing to perform this part of the contract. As stated, the factum of his readiness and willingness to perform this part of the contract is to be observed with reference to the conduct of the party and the attending circumstances. The court may infer from the facts and circumstances whether the plaintiff was ready and always ready and willing to perform this part of the contract. In this case, in the plaintiff, there is no pleading to the effect that the fund was available or he would arrange it within a particular time. And that is why, my lord, since no legal notice was sent and it was not brought on record, so it could not be marked as exhibit. To frame
This judgment 2023
23 para 24. In this case also, this 95 judgment was relied upon by
Read paragraph.
To ever and prove readiness and willingness to perform an obligation to pay money in terms of a contract, the plaintiff would have to make a specific statement to the claimant and adduce evidence to show availability of funds to make payment in terms of the contract in time. In other words, the plaintiff would have to plead that the plaintiff had sufficient funds or was in a position to raise funds in time to discharge his obligation under the contract. If the plaintiff does not have sufficient funds with him to discharge his obligation in terms of contract, which requires payment of money, the plaintiff would have to specifically plead how the funds would be available to him. To cite an example, the plaintiff may ever and prove by adducing evidence an arrangement with the financer for disbursement of the adequate funds for timely compliance with the terms and conditions of contract involving payment of money. Satisfaction of section 16C is compulsory for maintaining suit of a specific performance.
So in absence of any pleading, there was no occasion to frame an issue. The learned counsel has submitted that in absence of any pleading that the fund was that the balance fund was available with the plaintiff to make payment in terms of the contract. There was no occasion to frame any issue to that effect. What do you say so far as the agreement is concerned?
So far as
Agreement.
well, even if for the sake of argument I accept that
2-3 things I want you to address. One is the party. Second is the legality of the agreement.
well, the agreement, the plaintiff himself admits that the agreement was on behalf of the original owners or original leasehold owners, and they were not made party in this suit, despite having clear knowledge that I am the power of attorney holder of the executants of the power of attorney holder. And the case of the defendant has been throughout that he did not put his signature in the agreement, and this has been his continuous stand. There has been no change in his stand that he anyhow or one or the other way it can be presumed that he executed the agreement. And it has come, though specific details were not given, that the property stood sold prior to the execution of the agreement. So there was no occasion to enter into any agreement with the plaintiff. Even a date is given, and it has been consequently admitted by the plaintiff himself in his evidence that there was subsequent sale also. And had the plaintiff brought the subsequent sale deed from the recital, therefore it would have been clear that the suit property is sold prior to the execution of the agreement.
Why didn't you bring it on?
But it was understanding of, it appears that it was understanding of both the plaintiff and the defendant that they will not bring any material to demolish their case.
Plaintiff and the defendant.
The
There was an underlying agreement.
Plaintiff will not bring to demolish the case of the defendant, and defendant will not bring.
What kind of agreement is this?
Well, it appears from the reports. Otherwise, both of them were having clear knowledge that the property is sold, even pre-agreement and post-agreement. Despite that, no effort was taken by either by the plaintiff or the defendant to bring the clinching material, that is sale deed, to bring on record, to make things clear.
The learned counsel for the respondents has submitted that the evidence of both the parties revealed that there was an agreement. There were sale deeds prior to and post execution of the agreement, and therefore there was no occasion for the defendant to enter into any agreement of sale with the plaintiff. But both the parties did not take any steps to bring the agreement of sale on record before. He has submitted that.
I have not admitted to that there was a prior sale deed.
Two sale deeds you have admitted.
I have admitted that subsequent to the agreement of sale, one sale
Two
deed
sales.
was, two sale deeds were.
Two sales.
Subsequent, yes.
The learned counsel has submitted that the defendant or the owners of the property do not have the title over the suit property, which can be passed on to the plaintiff. He has also submitted that the owners of the suit property were not made party in the proceedings as the and therefore the suit was bad for non-joinder of necessary parties. The defendant was made party not in the capacity of power of attorney holder, but in his individual capacity, by stating that he was the power of attorney holder, by stating in the plaint that he was the power of attorney holder of the owners of the suit property.
One more aspect, the specific details of the suit property was also not given. There are suit property, the entire property is in two parts. 4/5 belonging to 4 brothers and 1/5 belonging to 5th brother. So since there is a agreement for sale of only superstructure, so exact detail of the superstructure is required to be given so that the person who is in possession of the remaining property is not disturbed from his continuous possession.
The learned counsel has also submitted that the suit was filed, the power of attorney, that defendant was power at best was power of attorney holder with respect to only 4/5 of the suit property, and the sale deed and the agreement was not in connection with land but in connection with superstructure over the land, but no specific details of the property was given so as to segregate 1/5 share and sell 4/5 share to the plaintiff.
Despite having clear knowledge that the caretaker was in possession of the suit property at a particular point of time as claimed.
In spite of having clear knowledge that caretaker was in possession of the property at the time of the agreement also.
Pursuant to it.
Pursuant to agreement. Caretaker किनका?
Income.
He says that the caretaker was appointed by the plaintiff.
One judgment out of 3, 2024 judgment has been missed to be placed. Para 8 and 10.
8 and 10 दोनों ना?
To take.
ये 2024 वाला जो जजमेंट इन्होंने साइड किया जिसमें पैरा
8
हम
and
तो
10.
8 and 10 दोनों ही लिखे.
नहीं है. Para 8 says section 16 of the specific relief act pass the relief of the specific performance of a contract in favor of a person who fails to have a readiness and willingness to
पैरा 8 and 10 दोनों ही. सूट कब का है
2007.
और अमेंडमेंट कब हुआ स्पेसिफिकली 2018.
18.
इसका पहले तो नहीं था.
Readiness and willingness.
रेडिनेस एंड विलिंगनेस तो था लेकिन कितना एवर्मेंट होगा प्लेट में ये तो नहीं था.
नहीं इसमें
रेडिनेस एंड विलिंगनेस तो था बट इट हैज टू बी प्लीडेड वाज नॉट देयर इन द प्लेट.
वहाँ था कि एस्टैब्लिश करना.
वहां से एस्टैब्लिश करना और 2018 के बाद से यू हैव टू प्लीड एंड प्रूव बोथ. तो ये जो आपका कहना है कि प्लीडिंग नहीं है इसलिए इशू नहीं बनेगा तो गलत हो गया ना. पढ़िए पैरा 8.
Para 8 of 24 days. But the act when
पढ़िए ना इसको भी तो
section
पढ़िए.
16 of the specific relief act 1963 prior to amendment with effect from 110 passed the relief of the specific performance of a contract in favor of a person who fails to have a readiness and willingness to perform his part
ये-
of contract.
ये पहले था कि बाद में था कि क्या? What was the effect of this 2018 amendment specific relief act?
Explanation 2 was introduced after amendment.
तो प्लीडिंग का तो कहानी आफ्टर अमेंडमेंट हुआ ना. जब ये सूट फाइल हुआ तब तो ऐसा प्लीडिंग का जरूरत नहीं था.
इसमें जरूरत था कि where contract explanation one was there, where a contract involves the payment of money, it is not essential for the plaintiff to actually tender to the defendant or to deposit in court any money except when so directed by the court. And section 16 reads that it was
16C का amendment पढ़िए.
amendment was also in 11018 who fails to prove ये what amendments है that he has performed or has always been ready and willing to perform the essential terms of the contract which are to be performed by him other than terms of the performance of which has been prevented or waived by the defendant.
ये तो बाद में आया ना.
ये बात है.
तो आपका आर्गुमेंट नहीं चलेगा ना. ये तो वो आर्गुमेंट.
लेकिन वो स्पेसिफिक डिटेल्स होना चाहिए सूट प्रॉपर्टी का, वो है कि इस केस में नहीं होगा.
He has never objected to the details of the suit property.
No, it was
Lord,
not. There is
There is a finding that there is
in the
no
judgment.
proper details on the suit property. That finding is there.
Section 17 says contract to sell or rent property by one who has no title not specifically enforceable.
चलिए आगे बढ़ते हैं.
I would like to read 3 pages of the review.
Schedule A at the page 13 of the plain leadership is the description of the suit property.
Only it gives only area.
It gives only area.
75 square feet.
North, south, east, west, surrounded, diagonal, everything has the building. Measurement 64 feet into 110.
This is the area of the land. There is no description of superstructure.
House situated at.
That's right. It is only superstructure mentioned. हाँ पढ़िए पढ़िए.
From internal page number 24. From first line, the superstructure that was standing here on has not been described, and the agreement to sale was not a sale by the absolute owner of the land, but was by the power of attorney holder of the legal heirs of the original allotee of the lease of the company. Therefore, what has been sought to be enforced is the sale of superstructure standing on the leasehold land. However, no description of the superstructure has been given in the agreement to sale, nor has the same been brought on record by way of any evidence. Further, section 17 of the specific legal fact provides contract to sell or let property by one who has no title, not specifically enforceable. I am skipping this portion. In the present case, Exhibit 1 itself provides that the agreement for sale was for only the superstructure and that the land it was standing on was a leasehold land. In the present case, the documents of title of the defendant, that is power of attorney, alleged to have been executed in favor of the defendant by the original allottees have not been brought on record. Further, even the agreement to sale was for the 4/5 share of the superstructure that the defendant could, by virtue of the power of attorney, sell on behalf of the legal heirs of the original allottee of the lease as has been pleaded. Further, the defendant has also submitted that Satyendra Nath Chakravarti had only left behind his wife Rita, but also left behind a son and a daughter who was not mentioned by the plaintiff in the pleading, and therefore the agreement to sell as power of attorney holder on behalf of four sons, namely so and so, purported by the defendant could not have been for selling 4/5 share of suit property. However, no evidence to that effect was made by the defendant. The plaintiff has brought the present suit only against the purported power of attorney holder of the legal heirs of the original allotee. This observation is being made only because of the fact that power of attorney, though copy of which was in possession of the plaintiff, was not brought on record. But it has failed to bring on record the power of attorney on record. Nor has the plaintiff brought on record the documents on the basis of which it was submitted that only Sri Rabindranath Chakravarti, Virendra Chakravarti, Mahendranath Chakravarti and Geeta Chakravarti had rights over the property of the sale by way of a specific performance was to be imposed. Therefore, the plaintiff has not been able to prove the capacity of the defendant, that is, his right over the sale property agreement which was sought to be enforced. Further, section 16 of the specific relief act also provides that the plaintiff should prove that he had performed or was ready and willing to perform the contract sought to be enforced. It was pleaded on behalf of the plaintiff that he had insisted upon the defendant to execute the agreement for sale on 1/7, it should be 1/6/2007.
1/6 नहीं है, 7/7 ही है.
1/6/2007. I have a copy of the agreement.
एग्रीमेंट नहीं है. प्लेंट देखिए.
Agreement for sale.
Plaint.
7/7/2007.
प्लेन में 7/7/2007. प्लेन पे चेक कर लीजिए 7/7/2007.
Para 12 says 1/6/2007. Para 6 of the
Of the 1/6/2007 is the agreement, but he has insisted upon to execute the agreement
after lapse of after execution of agreement 7/7/2007.
7/7/2007 after execution. Date is 1/6, and then on 7/7 he asked you to execute the sale duty.
And the defendant kept avoiding the same. It was submitted that a legal notice was sent to the defendant dated 27th of August 2007 asking him to perform his part of the contract. However, the legal notice has not been brought on record and the defendant is denied receiving the same. Further, the plaintiff has pleaded that his readiness and willingness can be inferred from the fact that he has paid a substantial sum of rupees 9,75,000 to the defendant, the money receipt of which was marked as Exhibit 3. The defendant, however, has denied receiving any amount from the plaintiff and submitted that the signature appearing on the money receipt.
This we have read. ये तो हम लोग पूरा ही पढ़े. The money receipt वाला तो पूरा
हाँ,
फाइल.
ये आज ये
The learned counsel has submitted that the learned trial court has considered the evidences on record and has held that neither the agreement nor the money receipt was proved. He has also submitted that the learned trial court has also taken note of the fact that the power of attorney was not produced, although the plaintiff claimed that photocopy of the power of attorney was handed over to the plaintiff. Even the photocopy was not produced before the court. The learned counsel has also, the court has also held that the plaintiff has not been able to prove the capacity of the defendant, that is his right over the suit property, comma, agreement for sale for which of which was sought to be enforced. The learned counsel has submitted that the learned court has passed a well-reasoned order which does not confer any indictments. Okay?
one last statement. The one witness who was produced for examination in chief was not produced for cross-examination. For that, adverse inference has to be drawn.
The learned counsel has also submitted that one of the witnesses whose evidence in chief was produced and who was a witness to the agreement but did not appear for cross-examination, adverse inference has to be drawn. And for that, he has referred to the judgment passed by Honorable Supreme Court.
2021 Volume 2 SCC.
2021 Volume 2 SCC.
Page 718. Para
Page
10.
718, para 10. That's all.
With regard to pre-amendment stage, last question. With regard to pre-amendment stage, that only pleading has to be given. 95 judgment.
95 judgment only says about proof.
It says
Not
proof,
not pleading.
but it says it has to be proved.
Yes. So issue ही नहीं बना तो proof क्या होगा?
But there is a general.
Issue नहीं बना तो proof क्या होगा?
There was a general.
That is why there was an amendment. इसी यही सब चीज के लिए तो amendment होता है. That there has to be pleading and proof both.
pre-amendment का सूट है ना.
हाँ.
तो नहीं होना चाहिए.
नहीं तब तो proof लिखने का जरूरत नहीं है. Pleading खाली देना है readiness and willingness and they will prove it.
95 वाली जजमेंट में कहा गया है कि प्रूफ ही करना.
Proof करना है. Issue बनेगा यही तो इनका कहना है. Issue ही नहीं बनाया तो क्या proof करें?
उसका तो जवाब है कि डॉक्यूमेंट्स ये नहीं है, तो इशू नहीं करें.
इशू ही नहीं फ्रेम हुआ तो क्या करें? इशू नहीं फ्रेम हुआ ना. प्री अमेंडमेंट पोस्ट अमेंडमेंट का कोई तो जजमेंट आना चाहिए.
हाँ.
आना चाहिए ना. नहीं मिल रहा हमको, हम खोज रहे हैं, हमको नहीं मिल रहा। प्री अमेंडमेंट एंड पोस्ट अमेंडमेंट का स्पेसिफिक रिलीफ एक्ट में कितना डिफरेंस हो, कोई मतलब डायरेक्ट जजमेंट नहीं मिल रहा। लेकिन अब एक तो जजमेंट को, हाँ बताइए, आपको कुछ बोलना है? You will refer to this amendment.
Yes,
The
definitely.
learned counsel for the appellant has submitted that the present suit was filed in the year 2007 and it relates to pre-amendment as section 16 with the bracket C was amended only in the year 2018 where there was a requirement to plead and prove regarding readiness and willingness, and as the law stood earlier, the plaintiff was required to prove his readiness and willingness. A statement in the plaint was sufficient. And this case is guided by pre-amendment and not post-amendment. Therefore, the judgment cited by the learned counsel for the respondent on the point of readiness and willingness does not apply to the facts and circumstances of this case. The court, having not framed any issue on readiness and willingness, the matter is withdrawn. Right?
And that judgment.
कंक्लूडेड। अब शॉर्ट नोट आप लोग मेरे को दीजिए, ठीक है? लेकिन हम कुछ बोलेंगे नहीं, आप दे दीजिएगा, क्योंकि अगर आप आर्गुमेंट्स के बाद कुछ भी बोलेंगे देन आई विल नॉट टेक केयर ऑफ दैट। ऑर्डर रिजर्व। हम लिखा तो सब कुछ दिए, लेकिन हमारे थोड़ा मेमोरी के लिए भी, वैसे कोई चीज़ छोड़े नहीं है लिखाने से। आई हैव टेकन डाउन एवरीथिंग। थोड़ा सा सीक्वेंस में आपको कुछ डाल देंगे तो इजी रहेगा।
Last meeting में ये should be dismissed.
हाँ, he has submitted that the interlocutory application seeking to adduce additional evidence is fit to be dismissed.
Monday they dismissed. Tuesday.
Tuesday, Monday. ऐसा कर दीजिए कि थोड़ा हमको होमवर्क मिल जाए छुट्टी में। यही ना है, आप लोग का यही सब साजिश है कि कोर्ट को होमवर्क मिलते रहे।
इस केस में ये इतना प्रिपेयर्ड थी एकदम।
Yes, she has argued very well. There is no doubt on that. अच्छा, are you relying on this? अच्छा, ये तो she has already that the purchaser was not made party. The learned counsel has also submitted that on account of the law laid down by the Honorable Supreme Court in 2024. नहीं, in
2024 volume 8 SCC.
in bracket 2024 volume 8 SCC 83 following the judgment passed passed earlier in reported in bracket 1953 bracket close to SCC 509, the subsequent purchaser was required to be made party, and in absence of the subsequent purchaser no effective dictate can be passed.
I am relying on whatever is flown from my law.
देखिए, जजमेंट अगर ठीक से नहीं करेंगे ना तो यही जजमेंट सब आप लोग साइड करेंगे, इसीलिए हमको केयरफुल रहने का जरूरत है। We are here to only serve the justice, right? हम लोग कोई पार्टीशन नहीं रखते, आप लोग भी नहीं रहते हैं, आप लोग भी सारे जजमेंट साइड करते हैं। We are happy, you are all responsible counsels। कोई ऐसा थोड़ी है कि during the course of argument I have observed that you are with the law at least, बाकी तो litigant अपनी जगह।